Welcome back to the morning show here on Arise News. The president of the Court of Appeal, Justice Zainab Bukachua, is at the center of a controversy regarding the petition filed by former vice president and presidential candidate in the 2019 general elections of the People's Democratic Party, Alhaji Atiku Abubakar, at the Presidential Election Petitions Tribunal. The judge is married to Alhaji Adamu Bukachua, a senator-elect on the platform of the All Progressives Congress, the ruling party. The party also of President Muhammadu Buhari, who's declared victory in the election, is being contested by Alhaji Atiku Abubakar. This perceived connection to APC by marriage to one of his stalwarts is currently the subject of a debate as to whether this will constitute a violation of the principle of conflict of interest enshrined in the Nigerian Constitution. Now, joining us to explore this is Liborous Oshoma, head attorney at Liborous Oshoma Chambers, a constitutional lawyer and public affairs analyst. Liborous, welcome to the morning show.
My pleasure. Thank you.
Good to see you again.
Yes, my pleasure.
Now, what is at issue here? Yesterday, the lead counsel to Alhaji Atiku Abubakar brought up this issue at the Election Petition Tribunal. And today, he's been given leave to file a formal application. And the presiding judge, Justice Bukachua, who is chairman of the Election Petition Tribunal, has adjourned the hearing of that case till May 22. And the counsel on the other side, Wale Olakunekwe SAN and Lateef Fagbemi SAN, also concurred. Now, what do you think is really the problem? If the presiding judge, the chairman of the tribunal, is married to an APC chieftain, is that an issue, considering the fact that judges are supposed to be without bias and to be impartial?
First and foremost, thank you for the opportunity to speak on this. Ordinarily, this shouldn't be an issue. But it has become an issue because of brand of politics that we play here, politics of suspicion. It's so bad now that politicians no longer trust themselves. And anybody that is affiliated or related to any politician is viewed with suspicion. That is so bad also that the day you criticize PDP, you are tagged an APC apologist, and the day you criticize APC, you are tagged, a PDP apologist. It's that bad. We have never been this divided the way we are now. And thanks to social media also, the politics of bitterness, is gradually taking over, our political sphere. And so it's on that note that you hear even lawyers sometimes throw decorum to the wind, and then rather than take steps, reasonably, would first and foremost go to the court of public opinion to raise issues. And so that's why you see what's playing out here. Mind you also, one of the reasons why the former Chief Justice of the Federation was investigated and removed, there were allegations though, was that he had a perceived relationship with some members of the opposition. And so it was alleged, I don't know if it's confirmed, that the government of the day also was not too comfortable with it. And so it's like almost at every turn you see, both parties at each other's throats. This wanting to get at this and that. You remember also Buhari's certificate issue. Oh, the president does not have a certificate. Show your certificate. Even though we all, like I said here the last time, constitutionally, all you need is, in the opinion of INEC, if you can read and write. And then the government also, the ruling party came up with Atiku, is a Nigerian citizen. All this, takes away the merits of what we should be discussing, the issues that surround, a transparent electoral processes. And so now, after the election, the lawyers have taken over, they are the tribunal, and then, they are at each other's throat, dealing with preliminary stage. And what happened yesterday is what should have been done before even taking the matter to the court of public opinion. You make a formal application, to the courts, citing, rule 12.1 of the Code of Conduct for Judicial Officers, and then Section 36 of the Constitution on fair hearing. as decided in Cape Dilliam and Madukolu, if that the panel is not properly constituted, and so that you do not, sure that fair hearing, will be guaranteed in such matters. And then, when you do that, what happens is, if your application is refused, you have opportunity to take it, upstairs to a higher court. But if it's by mail letter, it becomes an administrative issue. And so if it is refused on that ground, you have no right to appeal on it.
I see a problem here. I mean, Justice Bukachua, she's president of the Court of Appeal, right?
Yeah.
Almost every other case will still go to that court, one way or the other.
Yeah.
Now, I've read stories saying our husband is a politician, our son is also a politician, our brother is also a politician, and all of these three persons that have been named, they all have, cases, that will likely go to the Court of Appeal. So, I mean, what would you advise Justice Bukachua to do? To step down as president of the Court of Appeal so that she will not
at all. You see, that's why I said that, even members of the judiciary are also culpable in all of this quagmire that we are gradually getting into. And then also this will bring to fore this our knack for, appointing wives and daughters and children of politicians to the bench.
No,
if they are qualified, no problem. What I'm saying is, gradually, you see, we also know, we can't shy away from the fact that, every government appointment here, people lobby. And so, a situation where because Dr. Reuben Abati is a politician, and so he lobbies for the daughter or the son to become a judge, and then someday, Dr. Reuben Abati becomes a governor, and then there is a matter in courts, and the daughter or the son is a president court of appeal. There's likelihood of conflict of interest or bias or genuine reasonable, perception that there will be bias. And so, because the way we are going, very soon you will see names of long list of, judicial officers who are either children of governors, politicians, and all of that. And so what I am saying, in making this appointment, also there's need for the NJC also to try as much as they can to spread these appointments, across board. And then for the crisis that you talked about, I wouldn't advise her to resign from the Court of Appeal. If I were in a position, it's me, I'm not her, what I probably would have done after constituting the panel, I would come before the court and say, well, because I know the way politics is played in Nigeria, and because of certain interests, and because of my relationship, I would want to step down from this panel so that, I don't want, this to be a topic for debates in the public or for, there to be insinuations. Once you do that, the news will be agog of our integrity, our uprightness, and that should serve as a yardstick or example for conducting future political matters. But that didn't happen. And now what has happened is, first and foremost, the opposition party had gone public with the issue, which I disagree with though, before coming to court to make a formal application. I had expected that the reverse should have been the case. Make a formal application and then let the public begin to chew on it.
I tend to agree with you that I believe that Justice Bukachua should have recused herself. However, she did not. Now, she made a comment which I found interesting, buttressing your point about the correct procedure, probably a motion and not this letter. When she fixed hearing for May 22nd, she said that the matter is already in the public domain, so it will be heard in the public domain. Yeah. From that little comment that she made there, what can you infer? What is the likelihood, now that the Court of Public Opinion has been invited in, what is the likelihood that she will now withdraw? And can you also address the composition of the panel? There are 5 people. Yes, she's the president of the Court of Appeal, but her vote is 1 vote, is it not? So can you clarify?
Because first and foremost, let me take the questions, your questions first as they came. The fact that's why I said, when these lawyers should not allow themselves to be dragged into this fray of trying to please politicians at all costs. And then once that happens, you throw decorum, you ridicule your profession also. And then That's what had happened. If you, like I said, if you do an administrative letter to the PJ and she refused, that ends the matter. You probably won't have opportunity of coming back to court by a motion because she had decided on the matter via a letter. But if you do a motion and it is argued on the merits, mind you now, you have 5 justices, and they will decide the issue on the merits. And then if it is refused, you have a right to appeal to the Supreme Court. Let the Supreme Court also take argument from both sides. And once the Supreme Court makes a pronouncement on it, it becomes the position of the law also. And then having one vote, if there is we need to be careful also, because Lord Denny once said, when a judge sits on trial, the judge is on trial. When you sit on trial, the court of public, as a judge in a court, the court of public opinion also is trying your conduct. And you wouldn't want a situation as a judge where there is a tie of 2-2, and then you are the decider. And then either way you go, there are bound to be insinuations. If you go the way of APC, we said it before because her husband is, APC. And if you go the other way, they are bound to be, yes, she was the one. In spite of the fact that the husband is APC, she disappointed, her husband's party and all of that. So the best thing to have done or to do in that circumstance, you have capable hands. You're not the only one there. There are so many other judges who can do justice to the matter. The best thing to do, once there is this too much noise, you just say, we've seen it. Justice Justice Christopher, a former CJ in Lagos State, at some point during Al-Mustafa's trial, when the defense counsel made an application on the floor that he should recuse himself, he said, well, I will do that. And for a statement he made in open court, this wasn't about even relationship. And so once these things happen, so that you don't unnecessarily put yourself in the eye of the storm, because, like I said, it's a panel of 5 and you have 1 vote. Let's pray that you don't have a tie. And if you have a tie, it becomes 3-2. What happens? Either way, there are bound to be accusations and counter-accusations.
Well, your position is clear. You expect that, Justice Bukachua should stand down as the chairperson of the Presidential Election Petition Tribunal.
Yes.
But, it looks like she's not planning to do that. So in the event that she doesn't do that, do you think that we can say from this point, on the basis of what you have just said, that the outcome in this particular case, involving Atiku Abubakar and President Buhari, will be considered prejudicial?
You'll be a very good cross-examiner. I see where you're trying to come from, trying to put words in my mouth. I refuse to take that bit. What I am saying is, I can't sit down here to tell you that she is refusing to do that. No. My actions have not shown that she does not want to do that. She had said, the matter is in the public. So why don't we discuss it, argue it, like lawyers do, publicly? Bring an application, give the other party, who also are opposing publicly, the opportunity to have a bite of the cherry. So the judges will look at the application on the merits. She might have she's not the only person on the panel. She might have her intentions. She might feel, look, this matter, she knows herself more than the rest of us. She might feel, look, this has to do with law and not my family and not my husband. And it is not a matter that particularly concerns my husband here. And so why do you think that I will be biased? That might be her thinking. But depending on the argument for and against, it is those arguments that the court will look at and take a decision on, and not what she thinks or what she feels. And so it will not be fair on me to sit down here to say that she does not want to take that route. No, because I'm not close to her. I'm not in her mind. I don't know what she's probably thinking at this stage. And then also for a judge, it is not in every case where allegations of bias is raised that a judge excuse herself from the panel. It's not in every case. That's why in some cases, even when you make an application to the CJ, you know, for a state high court matter, even when you make an application to the CJ, in some cases, the CJ looks at the circumstances and said, no, I don't think that, you know, such a person will be biased in this instance. And so it's not in every case where the allegation is raised, even though Rule 12.1 says that you should recuse yourself when there's genuinely and reasonable, you know, suspicion that, you know, there'll be bias. But how genuinely and reasonable is subjective. It's subject for the court to decide. And so if she decides not to, you still have a right at the end of the day to go on appeal. And at that panel, she won't be on that panel on appeal. And then the appeal panel will look at the matter on the merit and give a decision one way or the other, either for her to excuse herself from it or that they really don't see any reason for why she should do that.
Let's look at the burden of proof for election tribunals. It's high. What is the likelihood of Atiku Abubakar being able to discharge this burden, especially since we have this issue with Justice Bulkachuwa, which may or may not, I'll be cautious as you are, be presenting a roadblock. And we also have the fact that he's been restricted in terms of accessing INEC server. How will he discharge that burden?
I was one of those looking at the parameters and the, you know, political happenings. I was one of those that had advised, even before the learned essay and Olisa Agbakoba did say he shouldn't go to court. On the day the election results were announced, I was one of those that said, I think I even said that on this panel, that he shouldn't, what I think he should do is to join hands, you know, because now Nigeria needs, you know, unity much more than ever. You know, that he should join hands with the ruling party to find, you know, a pathway to, you know, building blocks for successful, you know, government. But he's gone to court and he's raised issues that are very germane. And he has capable hands. The defense team also have capable hands. And you know, one very funny, and that's an aside, one very funny thing about all of this is that, you know, you see lawyers on both sides. Today, you see some of these lawyers on the side of the government. Tomorrow, you see them on the side of the opposition. It's, you know, the same thing, you know. So, and at the end, it is how well, because before you approach the tribunal, like you said, election petition matters and not just every other matter. If you are alleging irregularities, you need to prove polling unit by polling unit. Maybe that's why Doctor and his party didn't go to court. I don't know if they've gone now. You need to prove polling units by polling unit. And so if you do not have these facts, you don't just approach the court because you have the money. Oh, yes, there were irregularities, or because somebody alleged that there were irregularities, or that because, you know, some pressmen said there were irregularities, and yet you do not have the facts. If you have the facts, you'll be confident enough to say, well, I have the fact, and reading his claim, I won't say it's a tall order for him, like you have alleged. If INEC had come out to say there is no server, or that we didn't transmit election materials electronically, you know, these are things that can easily be proven. Science had gone beyond just this mere stop and search allegations. Science now, it's if you allege that there was a server indeed, or that, you know, there are ways you can prove that indeed, you know, there was a server, or that the figures are there. Because even an email, just an email that you send from A to B, that email would have crossed, you know, more than 1 million links before getting to that B. You thinking that, oh, I just sent a mail to him. And even if you delete that mail, there is a way they can retrieve that same mail that you have deleted. And so that's why science is very beautiful. And so it's gone beyond just allegations of, oh, can you prove this? And can you? So, and also, it will open a door of opportunity for electoral processes if you can prove scientifically, you know, all of the allegations that, you know, they have laid. And you remember, even Buhari, as an opposition candidate, did go to court against Yar'Adua. And, you know, by a slim, the elections were, you know, almost overturned. if not for, the fact that some of the judges of the Supreme Court, in their wisdom, said, well, we identify that there were irregularities, but that was where that word crept into our electoral jurisprudence, substantial enough, that they were not substantial enough to have annulled the election. And so let's see if Atiku Abubakar will be able to prove the substantiality of his claims of the fact that the elections were marred with irregularity, or that he actually won the election. Mind you, these are two claims. If you say elections were marred with irregularity, and so it did not comply with the provisions of the Electoral Act, and so those elections should be nullified. It's different from when you're saying you scored the highest number of votes and that you were robbed of those highest number of votes. And you can't plead the two at the same time. It will amount to blowing hot and cold from the same mouth. So that's why election matters are, they are sui generis. I wanted to use the layman's word, they're, special. And so forth. I believe that their lawyers, both lawyers, are capable to do justice, and also it will deepen, our electoral jurisprudence, and we'll learn one or two things from it.
Let me ask you, the Court of Appeal disclosed recently that we have, this year alone, 766 election petitions, and then 77 tribunals. Now, this was not the case in previous general elections. Do you think that this is necessarily a good development, or is it a comment on the conduct of the election?
In my opening statement, I said that we have never been this divided. Politically, we have never been this divided. In 2011, we thought it was bad, but 2015, it was worse. And then now, it's getting worse by the day with every election. And so situations where every candidate feels there's need to go to court, whether you can prove substantially irregularity or not. And so that's why some people say, after the election, you have everybody have their day, with Nigerian election. After the election, you have it's the lawyers' turn to have their bite of election funds. That's what some people say. And so, for me, I really don't think, in as much as I agree that electoral practices, our courts can develop, deepen electoral jurisprudence. We've seen in some cases. But I really don't think it's every election that we should approach the court on. There are some there are some petitions that ordinarily shouldn't go to courts, in my opinion. Because also, I must also say here that fortunately, I am also involved in some of the election petition matters. Oh,
you're also getting your bite of the election funds.
So it's not every election, matter that you should take to court. There are some that are very frivolous, and then you begin to, ask yourself, who is advising this petitioner? But, typical of us, we want to ventilate every issue in court, and we so much look forward to the court. And that's why the judiciary now also is in the eye of the storm. We look forward to the court, and we believe that elections should not be decided at the poll, but in the court. But if we see election as an opportunity to serve, and then at the conduct of elections, after the election, we don't necessarily feel that the court must be the decider. We can join hands to begin to build electoral practices, areas where there are challenges. We can make suggestions and make amendments, even at the National Assembly level, not necessarily going to court. Because I can tell you, that it was because of this, myriad of cases that even the Electoral Act was amended to streamline the time for dispute resolution of these electoral matters, because there were times where those days, for 4 years, election matters would be in court. And I can also tell you that more than 60% of these election petitions will be dismissed. They'll be, because also, if you see some of the petitions, if you see the documents, they're as high as this. And so, let's assume you have about 100 of those cases, or 70-something of those cases in court. And the panel has about 6 months to deal with all of that. How many are you going to genuinely, in all honesty, be able to look into on the merits if you have to treat polling unit by polling unit? And that's why I think politicians, in their wisdom, should find alternative way of ensuring that our electoral processes are, improved upon, not through the court process. Remember the waste panel report. It's unfortunate that the people who were the proponents of the waste panel report, who are now in government, do no longer see the need to begin to implement the recommendations of waste panel report. They feel it's been overtaken by then. But no, we have to go back at every turn, look at election, electoral act, and electoral practices, and find a way of ensuring that we consistently impose or build confidence in the process, that someday we won't have to wait till after a few months to election when we begin to discuss election, that anybody can approach the people through the election in confidence to say, look, if I lose the election, I am sure that truly, the people have rejected me. But when there's no confidence in the process, you lost an election, you don't believe that that's a true reflection of the votes, cast in the election. So that's why one of those challenges why everybody is going to the tribunal. And the tribunal also overwhelmed. And also, while we're complaining about the slow dispensation of justice, once you appoint members of the tribunal, the matters in their court, the everyday matters in their court also suffers, because those matters would be stayed or would be paused until they come back from their national assignments. And so one aspect of justice also suffers, because, there's this rush for everybody wanting to go to the tribunal. It won't, that's my personal opinion. Law develops and regulates society, but the way we are going, the speed at which we are, approaching election petition tribunal, it was so bad that Justice Kayode Esho did raise an alarm at the point that the way we are going, we're creating billionaire judges. And that if care is not taken, it will get to a time when the NJC will even dismiss judges and they will just, smile home because, having be a member of election petition tribunals, the benefits.
We're talking about the NJC. I don't know what your position is. There have been complaints about the composition of the National Judicial Council and whether or not it would be a better idea to even have state judicial councils, judicial councils in the states, instead of a federal National Judicial Council, and that, maybe perhaps the CJN should not be the chair of that National Judicial Council. But what do you think?
Yeah, the last crisis, or the current crisis with the CJN, exposed all of these issues that we have been talking about. I remember specifically during the travail of...
Justice Walter Onoge?
No, the former President Court of Appeal, Justice Ayo Salami.
Okay, Justice Salami.
I did say that a situation where the CJN single-handedly appoints about 15 or 14 members of the NJC, and that if you have a matter against the CJN, that there's no way you're going to get justice in such matters. And so it happened with Justice Ayo Salami's case. And so at that point, some of us had been calling for the amendment to that section and then the reorganization and overhaul of the NJC. In America, like you are aware, the Supreme Court justices don't retire because the society feels they've invested so much in them at that level to just retire at 70 or 65. It's when you're tired, you say, okay, you can no longer continue. And so, but we have justices of the Supreme Court, of Court of Appeal that have retired but not tired. And so what stops, us from, also forming or finding a way of making some of these persons, chairman of the NJC? Thank God Justice Abdullah, a former President Court of Appeal, had to come to the rescue when there was a crisis between the outgone CJN and the current acting CJN. The NJC was in the eye of the storm. And so that also brings us to the fact that now it is time for us to look at the NJC and ask ourselves, what do we want to do? Do we want to retain the current body as it is, which is not working? And then this ad hoc basis that they sit. You hear allegations of corruption against judges every day. And you submit petitions. The last time NJC said they said they had about more than 100 petitions waiting to be dealt with. But if you have the NJC, you have members who have the time on their hands to sit, often to be able to address these cases. The public also would have, and lawyers also will have confidence in the NJC to approach them with issues. And so that also will ensure and enable the NJC to be self-cleansing. But what you already have is, in some cases, I remember discussing some of these issues on air, and a senior lawyer called me and said, look, I salute your courage, because some of us won't do this, because you're scared that you'll be a target when you appear before some of these. But also, I've had instances where, some of these judges also salute our courage for being able to talk about these issues as burning as they come. And so, for the NJC, I think there's need for us to look at the NJC and find a way of overhauling it. Also, we swept the Ayo Salamis crisis under the carpet, and now we have seen a situation also where the NJC, the chairman of the NJC, who is the CGN, also is in the eye of the storm, and he appoints members of the NJC, about 14 members, and then you begin to ask yourself, will the NJC be able to deal with allegations of corruption against the appointer? That was a big problem. And so the public now, the lawyers or the judges who ordinarily decide cases, the court of public opinion were watching to see how they would deal with that matter, which is still, had not, still be conclusively dealt with. And so I think for NJC to truly do a self-cleansing process, this time is now for the stakeholders, lawyers, judges, and people who believe in the fact or the slogan that the judiciary is the last hope of the common man. It's now the time for us to find a way of reinstilling back that confidence in the process, for it truly, not just to be seen to be the last hope of the common man, not just to be the last hope of the common man, but reasonably be seen to be the last hope of the common man.
I want to take you back to your previous answer. You raised a lot of issues. I agree with you on the fact that courts should not be an extension of our electoral process. No. It's an encroachment on the duties, the functions of the electoral management body, which need to be resolved, strengthened. But I do think it's a bit much to ask a person who feels cheated, who feels that they have actually been robbed, to now walk hand in hand with the robber. So there needs to be some kind of a balance there.
Let me give you an example. What do you call it? Al Gore felt robbed in U.S. Even Hillary Clinton felt robbed also.
But are they working hand in hand with their...
but see, look, let me tell you the way it works here. If you see the banter going on between APC and PDP, it's uncalled for.
Yes, there's no need for ad hominem attacks. But I don't want to be distracted, because I just wanted to make that point.
I'm going there. You see, there are ways you can disagree without necessarily, or agree without necessarily working with. There are also ways you can criticize without necessarily raising dust. A situation where you look at the entire process. Why I said that, not that you can't approach the court, where there are genuine concern to approach the court, you will approach the court. But a situation where every frivolous application, every vexatious petitioner wants to go to court.
Yes, I agree with you.
And so, once that happens, you unnecessarily bog the judicial system with all kinds. And so, there are some that you need the court to make a pronouncement on. And thanks to the court also, if not for the court, people like Oshomole wouldn't have become governor. People like Peter Obi wouldn't have become governor. But those were cases. Rotimi Amechi wouldn't have become governors. These are areas where the court looks at the process and say, look, there are substantial, issues to be answered here. Not the frivolous one. That's what I'm saying. I'm not saying nobody should go to court.
I appreciate that, and I agree with it. Then you also mentioned Justice Kayode Esho, which takes me to the Oyetola case. In Chinwendu and, I can't pronounce, Mbambila, Justice Kayode Esho said the time is no more when matters are decided on technicalities rather than merits. yet you now have this decision, the Yetola case, the Osun State Court of Appeal decision. What is your comment on that?
You see also the issue of technicality to some extent, most especially in electoral matters, is subjective, largely. Because that's why I told you, I said the election, when you query election and electoral processes, what the court looks at is substantial compliance. And so, but if you're looking at substantial compliance, the aggrieved party might say, the court is looking at it from the technical perspective. And so...
No, let me rephrase what she was saying. When she referred to Kawude Show, this was during the golden age of the Nigerian Supreme...
I don't like being rephrased. You can follow up, you cannot rephrase.
No, okay, maybe that's not the right word, but let me put it in another way. The golden age of the Supreme Court, when you had Kawude Show, you had Justice Oputa, you have all this Irikefe, yes. That was the era of what we call judicial activism.
Yes.
Now, what has happened to that tradition of judicial activism? Why is it that everything now is all about the competence of the matter, of the filing of the case, or technicalities, because it happens all the time, despite the assurance.
Even at that time.
By the president of the Court of Appeal, the same Justice Bukachua, that judges should not, focus too much on technicalities.
Even at that time,
yes.
What the layman calls technicality, in the eye of the law might not be technicality. Let me give you a very simple example. To the layman, the issue of right of action might be a technical issue, but the court will not close its eyes to the power of an applicant or a complainant to the right of action, whether you have a right of action. There might be a cause of action, but if you do not have a right of action, the court will close its eyes to it. But to you, the court just looked at it technically. Even at that time, also, there were issues that were dealt with that except you read in total the judgment of the court, you would think that it was decided on a technical level. Because also, there are procedures, like Femi Falana did say in one of his interviews. He said, the procedure adopted by the court or by the prosecutor in taking statement from a accused person, the court would close its eyes to it. But to you, it might look technical. The Administration of Criminal Justice Act says that the lawyer of the accused person must be present at the time the confessional statement was obtained. This is a defect this is a section that is meant to cure certain defect. And so if you now say, the man made confessions, we obtained the statement, and then you get to court, and the first question is, was his lawyer present? And he says no. But he made confession. He confessed. And the court says, well, we can't admit this documents in evidence. And so on the basis of that, on the strength of that, and those are the documents that you are relying on to convict him. And then let me now go to the electoral matters. In the same Supreme Court, the Supreme Court decided an affidavit must contain the name of the deponent, the name and signature of the deponents. And now, in 2011 or so, the same electoral matter, because of the need to hide the identity of deponents, lawyers will use A, B, and C as deponents because you want to hide the identity. And the court rules to say, look, there is no deponent in this affidavit or witness deposition. And it is the witness deposition in support of your petition that you're relying on as your evidence in the matter. And so when the court makes such pronouncement, you're going to look at it from the point of view of, these are technicality. But no, those are what will enable the court to decide the matter on the merit. And so when the court is talking about technicality, probably looking at the technicality on the part of, and then another one quickly, there are situations, the court no longer grants amendments, or because of the sui generis nature of electoral petition, and to ensure that matters are not unnecessarily delayed, they no longer grant amendment or extension of time to file defense. And so, if, for example, there is need, or for situations where a defense is filed by somebody who does not have the authority to file the defense, or who is not instructed to file a defense, the court decide to accept that defense. That's where you begin to talk about technicality, or that the court refuse you from filing a defense because a defense is in the fight. That's when you begin to talk about technicality, not when the court decides to apply the rules of electoral acts. And because it doesn't favor one party, so it's a technical matter.
It's been dismissed as technicalities, right. The grounds on the appeal were completely different from the grounds on which the tribunal adjudged Adeleke as the winner. The Osun State Court of Appeal,
it's a matter for the Supreme Court to decide whether the grounds of appeal
so where do you
are
think,
different.
So I'm asking you, where do you think it's heading? What, if you had to
And you see, most election petition matters, when they come from the tribunal, even when judgment was given in favor of Adeleke, I refuse to comment on the matter, because for me, I wait for the apex court. It is when the apex court take a final decision of the matter, it becomes a position of the law in as far as such, matters are concerned. And so that's where I begin to say, well, it affords you an opportunity to review both the tribunal judgment and the Court of Appeal judgment, and then you have a better understanding of how the matter went. But at this stage, it's still very, very premature, like we say, to condemn either the tribunal or the Court of Appeal, because also that will surreptitiously amount to prejudicing the mind of the Supreme Court.
Well, let me ask you about the electoral process. The National Assembly has passed the Electoral Act Amendment Bill. Hopefully, the executive arm of government will be pleased with what has been done. But in the light of our recent experience with the general elections, what other reforms would you recommend to the electoral process?
Thank you. I completely... You remember, sorry, quickly, you remember it was failure of the executive to assent to the amended electoral bill that led INEC to go to town to say, look, because a lot of people now started losing confidence in the election. And so that was what led INEC to go to town to say, don't worry, we've trained workers, and we're going to transmit election result electronically to repose confidence in the process that INEC was unbiased. And so now, all of those back and forth, and we went to the election without, an amended electoral act. And so now is a good time for us to look at, yes, the elections are over, a winner had emerged. No matter the misgiving, there's need for us, that electoral act that was amended, there's need for us to look at it and say yes. And then, secondly, we desire an electronic election now than ever. From the logistic problem that is always associated with INEC and election, it is time now for us to look at our elections when every new thing, not everybody accepts, every novel idea. Even the card readers that we are all praising today, when it was introduced by Jega, the National Assembly condemned it. The National Assembly invited Jega to come educate them on the workability of the card reader. I remember Senator Udoma Egbe, who was in PDP then, now is in APC, on the floor of the Senate vociferously opposed the introduction of card reader and even labeled it, electronic voting, by other means. But in as much as a lot of people condemned that idea then, we saw how it has helped to also streamline fraudulent practices in our election. And what happens with election is at every turn, you don't wait till 2 months to election before you begin to amend your electoral act. At every turn, all of the challenges witnessed during the election, you sit down with stakeholders and look at them and find a way of, either reforming some using the instrumentality of the law or your practice. And we have consistently seen that logistics is a big problem to INEC. And for logistic problem, INEC had to postpone general elections, even state elections. And so, how do we cure that logistic problems? Won't it be nice, this idea of, having to transmit materials, election materials, and it was even very laughable when the results were being read. A lot of people got tired. You see, massive, result sheets and, all of those things. When you can do these things, transparently. We monitor, Western countries' election here. You sit down in your studio here, and you don't have to wait for the electoral body. You don't even know them. You don't wait for them to begin to, everybody would go to the state capital or the headquarters to begin to read results one after the other, when even the results are already known, by the electoral umpire. And so it also builds confidence in the process. And so that's why now that elections are over, INEC needs to begin to look at, innovative way of ensuring that, as you are voting, even if you retain the manual process, there should also be an electronic process that, people can monitor. As you're voting, I want to see a situation that, you have electronic board in the polling unit. My polling unit, for example, as I'm thumb printing, I'm seeing the result counts. Right there, it's transparent to everybody. With that, everybody would, even if you're complaining, deep down inside of you, you will know that this election, I didn't perform well, so I need to go prepare. Unlike where, everything is done in secret. That also will be akin to having an open ballot, a secret ballot system, where you vote secretly, but immediately the result is open. So all these are some of the reforms I hope to see in our electoral amendment process, that, we build confidence in the process. And then, one very last thing, very important, is need for us, INEC is especially, to begin to use certain persons as example. People, the law had made provisions, beautiful provisions for electoral offenders. But a situation where somebody go to a polling unit, destroy polling materials, and then he's arrested, the next day he's released. What you're telling those who have the capacity to commit electoral offenses but that we're not committing electoral offenses there is that it pays to commit electoral offenses. And so, in those cases, INEC will cancel results from those areas. And then you now announce a result eventually. You say, well, because the result would not affect the overall outcome. Whether it affects it or not, you have disenfranchised some persons. You've denied them the opportunity to be part of the process. And it comes once in 4 years. The process, choosing somebody that would govern, the state, even if it's just one vote, denying them. In some countries, refusal to vote is an offense. And so, but you have a situation where your country would deny you the opportunity to even participate. And then we just go back after the election as if all is it's okay. We shouldn't do it.
Yesterday, we spoke with the registrar of JAM, who is diligent in having anybody, even suspected of electoral malpractice, investigated, prosecuted. Same things to the logical conclusion. INEC has dropped the ball in that regard. A few months ago, we had somebody from INEC on this show who did not even know that the Electoral Act dictates that INEC should prosecute people.
A lot of them, because...
She said, no, it's not INEC. It is, in fact, INEC.
No, it is INEC by section 150 of the Electoral Act.
She didn't know that. So I'd like to hear your thoughts on the Court of Appeal's ruling on former Chief Justice Walter Onnoghen's applications, especially the fact that they held that he had been denied his rights to fair hearing, which is a fundamental right under Section 36. Why were there was no restorative remedy for him? Why did they say that with a full stop and not a comma?
Like I said before, I want to see the way the Supreme Court will make, the pronouncement of the Supreme Court on this matter. Because that Court of Appeal pronouncement, I view it, half and half.
Yes.
And so I would wait to see, because once, I don't know if the matter has gone on appeal now, but I learned that, the parties were going on appeal. And so, because if it is allowed to remain, it will also open a door to, our right to not just a fundamental right to fair hearing. And it will give a window of opportunity. Your right to fair hearing can be abused.
Yes.
And then they say once the process had been completed, and so you become an academic exercise. And so I want to see, like I said earlier, how the Supreme Court deals with it. And then whether it becomes a law, then we can now take it up and begin to discuss it.
It's quite disturbing, especially when you have former governor of Kwara State, as he then was, Bukola Saraki. When he removed his Chief Justice of Kwara State, she was reinstated. It does not at any point become an academic exercise to restore a wrong that has been done.
No, it doesn't. It doesn't, because if, like we say, ubi jus ibi remedium, where there is a right, there is a remedy. And so if that right had been violated, the court should be able to remedy that right. But also, mind you, there are certain instances That's why the justice here, in as much as we say justice is blind here, our justice sees. And so depending, if the matter is more political than judicial, you're going to, see one or two, political interpretations.
Well, Liborous, we should let you go.
My pleasure.
We had a very good time with you this morning.
Always my pleasure.
On the morning show, and thank you for, always, honoring our invitation.
My pleasure.
Thank you very much.
It's time now for a short break on the morning show. When we return, we'll have a Rise News analyst, Emmanuel Ofeni, join us to review top stories in today's newspapers. Stay with us.